Okay, next. Rights of the parties to produce evidence. Next, rights of the parties to cross-examine the witness each other. Right of the parties to cross-examine the witness of each other. Next, right of the parties to know the evidence of each other. To know the evidence of each other. Above one is to cross-examine the witness of each other. The next one is know the evidence of each other. Next, doctrine of atrifois, atrifois acquittal and atrifois conviction. Section 300, double jeopardy. Next, 11, public trial. 12, fair hearing. 13, right against bias. 14, right against ex post facto laws, not to retrospective. It is a concept of constitution. Next, right against self-incrimination, 20 clause 3. Next, benefit of doubt should always given to the accused. Benefit of doubt should always given to the accused. Next, free legal aid to the parties. Free legal aid to the parties. Next, equality in presenting the case between the parties. Equality in presenting the case between the parties. These are the 18 principal features of concept of fair trial. Now come to first one, adversary system of procedure. Adversary system of procedure means criminal justice procedure, how this trial is conducted, what is the basic system of this criminal justice is called, there are two types of systems. One is adversarial system, another one is inquisitorial system. Adversarial system, inquisitorial system. So what is the difference? Adversarial system is basing on some features contrary to the inquisitorial system. In India, we have adapted this adversarial. This adversarial means this is the duty of the state. That means duty of the prosecutor to prove the allegations against accused. That is one of the concept. Prosecutor representing the state accuses the defendant. That means accused. Commission of some time. When open the any trial, prosecutor says, Your Honor, this person has committed so and so offense. So what does that mean? What does that mean? So prosecutor representing the state is making some allegations against the accused. Then the accused is being given some opportunities to defend himself. That is other side. So other side, that the accused is having opportunities to defend himself against the accusations made by prosecutor. So these are the two opposite sides. Then what is the role of the judge? In inquisitorial system, judge is having good role. That means he can interfere and ask questions on the side of prosecution. But in the system of adversarial, the judge should be neutral. The court should be neutral. In other way, it is like an umpire. That doesn't mean he kept quiet in the entire trial. Court is having some powers, but it should not take any side, either prosecution side or defendant side, accused side. It just trying to be neutral and valuing the witness, weighing the evidence. So, in adversarial system, this is the basic principles. One is prosecution side, they have to make allegations against the accused. They have to prove the allegations beyond reasonable doubt. Beyond reasonable doubt also. What is the meaning of beyond reasonable doubt? Beyond reasonable doubt means there should not be any doubt on the commission of any offense by accused. It appears that he may be committed. That is not correct. In criminal case, in criminal trial, it should not be appears or seem to be some doubt. There should not be any doubt. Beyond reasonable doubt, prosecution should prove the case of the accused. Already we discussed one of the, as a principal feature, if there is any benefit of doubt, it should be given to the accused. So there should not be any doubt. This is also concept of adversarial system. And also, legal aid should be given to the accused or parties. Why? Why? Because it is a fair trial. Suppose the accused is a poor person. He cannot afford to engage a lawyer. Without, in such a case, without any lawyer, without representation from the accused, can trial may go on? And what do you call it? Conviction can be given? No. Without representation, without there being any opportunity to defend his case, there should not be any trial or conviction. That's why, because of he is poor, providing legal aid is the obligation of the state. So state should provide that legal aid. That is section 303. You see section 303 of CRPC. It mandates, it directs the state to provide legal aid. If there is any absence of legal aid to an what do you call it, any indigent accused, then it is not valid. The trial can be set aside. The trial can be set aside. So there is a Supreme Court judgment. Okay, so this is concept of adversarial system. Judge is having some powers, of course, but that doesn't mean judge can interfere and ask questions on behalf of prosecution to find out to bring home the guilty. It is the duty of the prosecution. That is the basic picture. The powers of the court are there. Like you see section 321. Framing of charges. You see, prosecutor can only make allegations that the accused is committed so and so wrong. But who frame charges? Charges will be framed by only court. That means magistrate. So, basing on the evidence, basing on the facts and circumstances of the case, The duty of framing charges rest with the court. Only court is empowered to frame the charge. And also, without consent of the court, the prosecutor cannot withdraw the case. Section 321. Section 321 of CRPC. Once the allegation is made by the state through prosecutor, he cannot go again. He cannot go back again unless the court grants permission. So that power is with the court. And also compounding of cases. Suppose in some case certain offenses are compoundable. Compoundable means compromise can be done by both parties. They lodged the case and they themselves, after some time, due to the interference of elders or due to the counseling by somebody, family members, they can compromise the case. That is called compounding. Where this compounding can be done, it is only in the court. With the permission of the court. Some of the offenses are with the permission of the court. That means some cases automatically cannot be compounded. If you see section 320 of CRPC, it gives list of the case, which cases can be compounded, which compounded without permission of the court, which cases cannot be compounded without permission of the court. So court is having some power even in regarding compounding of the cases. That's why in this way, section 311, court can examine any person as a court witness. So what is that? Neither prosecution side produced the witness, nor defense side produced the witness. But court itself can summon any person as a witness of court witness to find out the truth. So this is also power of the court. And 313, examination of the accused. At any time, court can examine the accused to enable him to answer the evidence against him. Already we discussed this concept. Section 313, examination of the accused. So all these are the powers of the court, but at the same time, court remains neutral. Court remains act as an umpire without interfering both sides. This is called adversarial system. Come to next feature, presumption of innocence. As already I told you, this concept is a cardinal concept. You see, in India, the percentage of acquittal is high. That means if state registered 100 cases against accused, out of 100 cases, only 5% of the cases are being ended with conviction. The rest of the 95 cases are acquittal. And what does that mean? Till this trial is going on, the accused has been treated as accused by society. Till proves the guilty or acquittal, society look him as a criminal. But once, if it ended with the acquittal, then what is his position? So, the Universal Declaration of Human Rights principle, what is there in Article 11? Every accused should be presumed as innocent. The burden of proving the guilt of the accused is upon prosecution. It continues still throughout trial. So, this is called presumption of innocence, is also concept of fair trial. Next, independent, impartial and competent judges. Already I told you that 479, 480. The judge or tribunal or the court which conducting a trial regarding a case should not have any interest in that matter. Suppose one case is being run in the court. Either accused side or prosecutor, prosecutor state side, that means victim side. Judge is having some relation. Can that proceedings go on in that court? Suppose wife filed a 498A case against husband. The trial has come into judge, one of the court. The complainant and judge are relatives, distant relatives or some relation. Then what is the fate of the accused? So, the tribunal or court should be independent, impartial. Impartial. Here we are saying only impartial. Independent means there should not be any influence of the executive. There should not be any influence of some other body, some other on the court. That's why CRPC has been enacted, amended. Earlier, judge, magistrate, judicial magistrate and executive magistrate are part of the CRPC. But to separate executory from judiciary, amendments have been taken place. That's why all judges posts, now you want to become a junior civil judge. Who will conduct an exam? Though notification given by the state, recruit by state only, but supervisory control of the judge post, judge career and entire proceedings only by High Court. GO has to be given by government order, has to be appointment of order has to be given by the state only. But once appointment is over, GO has been completed, the High Court only supervise and regulate the courts, judges, their conduct. So like that, independent. Judge should not get any influence from any outside of the society, executive persons. Otherwise, some dictations may come from the executive. Even sessions judge and other judges recruitment process and their service matters, disciplinary proceeding, everything in the High Court. Already I told you section 479, 480. 480 says that no advocate to be sit as a magistrate in the same bar. Suppose one person is practicing, one lawyer is practicing at Delhi, or in some bar. And the same bar, he cannot sit as a judge, magistrate. Why? All the other members are his associates. Some advocates may be his friends, some are his enemies. So there is a chance of bias. So that CRPC prohibiting such a proceedings. In the same way, 479 says, the magistrate should not have any interest in the case. If he is having any interest, financial interest, personal interest, any type of interest, he should not hear the case unless the higher court grants permission. So this is the independent and impartial tribunal or court should be there. It is also concept of fair trial. Come to venue of the trial. Trial also, the venue of the trial. Venue means place where this trial has to be conducted. Where trial has to be conducted? You go to sections 177 to 189. Section 177 to 189 gives various situations where a trial has to be conducted. If you read all these sections, we can understand that these rules are framed keeping the fairness of a trial. Suppose you take 177. What 177 says? Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. That means where offence has been taken place before the local jurisdiction of in a court, there only trial has to be conducted. So what is the benefit to the accused by incorporating this rule is he can produce witness without there being any problem. He can produce witness. Suppose it is being tried in any remote area, any distant area, how can he produce to defense side his witness? Witness may refuse to come. Evidence may be difficult to produce. So this is one. All other you see section 406. What is section 406? Transfer power of High Court. Power of the Supreme Court, 406. 407, power of the High Court. What it is says, whenever it is made to appear to High Court that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto. The first point, the reason for transfer of that case is, suppose High Court feels that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate, then it can be transferred. So here, fair trial, the word fair trial has been used. If High Court feels that any subordinate court, this trial goes, it may not be a fair trial, impartial trial, then court can transfer it. Suppose some corruption allegations. So you see Jayalalitha, some chief ministers, some high-profile persons. There are allegations against government funds has been misappropriated. When trial is going, somebody says because of their ministers, chief ministers, or influential persons, trial may not be impartial. That's why Supreme Court transferred the corruption cases of Jayalalitha to Karnataka. These are These are being happened. One Andhra Pradesh case has been transferred to Delhi High Court. So, fair trial, the concept of fair trial is important. That's why 407 powers have been given. And come to when rights of accused to know of the accusation. This is another right of the accused. Some disturbance is there here. Just 2 minutes. You please wait 2 minutes. I will continue. Okay, next one is right of accused to know the accusation. What does that mean? The chapter charges, relating to charges. The accused should know what wrong he has committed, what offense he has committed. So, while starting the trial, judge should say in written form, judge should frame charge. Charge means accusation. Charge means accusation.
मैं चाय बोलल गेलिए हम बनवाए दिन
So, if it is a sessions case or warrant case, you just sessions case, warrant case, normally court will frame charge in written and explain him before starting the trial. It is summons case, there need not be because it is a less serious offense. Orally say, so orally told by the orally communicate to the accused that you have committed this and this offense. So, right of the accused is to know of the accusation. If you read the sections 211 to 224 charges chapter, you can understand why these are happened. Okay, come to next right of the accused, next feature of the principle of fair trial. That is called the accused person to be tried in his presence. The other principle is the accused person to be tried in his presence. Normally, while granting bail, one condition imposed by the court, you should be available to the trial. You yourself has to submit before the court when trial is commenced. That is one of the conditions. Without application, without permission of the court, the accused should not be absent before the trial proceedings. Why? Why this condition has been given? Section 273 CRPC, you see. According to section 273 CRPC, the evidence is to be taken in the presence of the accused person. This was one of the other principal feature. So he should know what is going against him. The accused should know what is happening against him in the court. Why he should know? To produce defense himself. To produce defense for that evidence. To give opportunity to him to counter the evidence of the prosecution. Section 317 of CRPC says, unless the accused takes permission from the court. Normally, section 317 CRPC is called absent petition. All lawyers, junior lawyers will file first only absent petitions. Seniors will say, you fill up that application of absent petition and file in the court by saying that accused is having some favor or something. This is regularly happening in courts. 317 petition. It is called 317 petition. At any stage of inquiry or trial under this code, if the judge or magistrate is satisfied for reason to be recorded that the personal attendance of the accused before the court is not necessary in the interest of justice, or that the accused persistently, so the satisfaction of the judge is important to grant exemption to dispense with his attendance in the absence of accused to conduct proceedings. That too, he should be represented by pleader. So why this stringent, why this hard provision has been made? Because he should be present in trial to know that what is going against him. So this is the one of the reason. Next, as discussed, evidence to be taken in presence of accused. It is also the same concept. If he knows the evidence, suppose one witness is there, he is saying something against this defense, this accused. He is committed so and so offense in front of my eyes on that day, so he should be punished. Then the accused can understand whether that person is saying right or wrong. Suppose that person is having some enmity with the accused, he can disclose that person is my enemy. So intentionally he is giving false evidence. Every evidence. Section 273 mandates like that. Except as otherwise expressly provided, all evidence taken in the course of the trial or other proceeding shall be taken in the presence of the accused. So shall be taken in the presence of the accused only. So that is the concept of behind this. You see, section 279 says evidence should be in language of the language also important. The language also important. Why the language? Whenever any evidence is given in a language not understood by the accused and he is present in court in person, it shall be interpreted to him in open court in a language understood by him. So interpretation also necessary. Suppose in Delhi, one person has been brought from Andhra Pradesh. In a case, trial is going. Evidence is going in Hindi language. He doesn't know Hindi. Then what is the duty of the court? Court should tell in his own language. Otherwise, he doesn't know. Why this provision has been? It is also a principle of fair trade. So, these are the important concepts. If we see the provision independently, we can't understand. We only understand that language should be interpreted if it is otherwise in the accused language. Why? What is the background behind this provision? We cannot understand unless we read this concept of fair trade. Suppose you deaf and dumb, then what about? Suppose accused is deaf and dumb. If he is unsound mind, there are certain provisions. Accused is unsound mind, there are certain provisions how to proceed against unsound mind accused. Then what about deaf and dumb accused? There is another provision. 318. If the accused, though not of unsound mind, cannot be made to understand the proceedings, the court may proceed with the inquiry or trial And in the case of court, other than a high court, if such proceeding result in a conviction, he is not unsound mind. That means he is not mental person. He is okay, mentally fit person. But what is the proceedings? What are the proceedings against him? He cannot understand. Because of he cannot hear, he cannot talk. So court cannot make understand him. Then what is the position? Then court has to continue the proceedings. If it led to conviction, then it should send it to the High Court with a report. These are the circumstances under the trial has been gone and conviction has been given. So take a decision. So High Court, after examining the entire situation, will take a decision whether conviction can be sustained or set aside. So it is the duty of the High Court. Why High Court has been given such power? Because that is big court, that is superior court, it can understand properly. So this is the fair trial concept. Next, right of the accused person to cross-examine prosecution witness and to produce evidence in defense. If there is no cross-examination of the evidence, there is no meaning for that. Because only truth can be elicited from cross-examination. The cross-examination is very important in every trial. If they gives false evidence, how can a person find out his falseness? Only through cross-examination. If there is no cross-examination, what is the meaning? Accepting of evidence of somebody as it is. Then there is no meaning. Supreme Court in several cases held that a criminal trial which denies the accused person the right to cross-examination, prosecution witness, it is a weak foundation that cannot be considered as fair trial. Cannot be considered as fair trial. If there is no question without not only one point, every witness, every document, there must be an opportunity to the accused to cross-examine, to counter it. Okay, in later stage we can discuss that in detail. Next one is expeditious trial. Expeditious trial means speedy trial. Having speedy trial also, principle of fair trial. Section 309. Section 309 says every inquiry or trial, the proceeding shall be held as expeditiously as possible. And when the examination of witness has once begun, the same shall be continued from day to day until all the witnesses or attendants have been examined. So day-to-day trial has to be done. Expeditiously done. Expeditious means speed. Because if the trial continues years together, decades together, what happens? Witness may die, evidence may diminish, evidence may eradicate, may be diminished, may be destroyed. So lot of developments may take place. That's why some acts prescribing time for trial. Suppose you take DBC and SC/ST Act, they prescribed time limit to complete the trial. 60 days trial should be completed. 90 days trial should be completed. Some are there. Some provisions are there fixing time limit to completion of trial. Even in Andhra Pradesh, Disha Act is there. 21 days trial should be completed. Now, in recent Supreme Court, in life imprisonment given for a rape accused, life or death within 13 days or 14 days, it has been set aside by Supreme Court. Speedy trial doesn't mean hasty trial. So, completion of trial early is necessary, is concept of fair trial according to section 309. You read 309. Next, earlier it is not part of the fair trial, but in Hussainari Cotton versus State of Bihar, Supreme Court held that speedy trial also part of fair trial. It is an ingredient of reasonable, fair and just procedure. So then onwards, the speedy trial come into picture. Of course, there are certain limitations. As I told you now, in the name of speedy trial, it should not be hasty trial. Without giving proper opportunity to produce evidence, witness, there should not be hasty trial. Next, section 300, double jeopardy. It will come again. We have to discuss it in detail. What is section 300? It is Article 22 concept. If a person is tried and acquitted or convicted of an offense, he cannot be tried again for the same offense or on the same facts for any other offense. So there are certain ingredients to attract this doctrine, double jeopardy. If a person is tried, that is one point. So trial must be completed. What is the end result of the trial normally? Either acquittal or conviction. So that is completed. So 2 steps completed. Regarding what? Of an offense? Offense. One offense is there. So when one person is tried, acquitted or convicted of an offense, he cannot be tried again for the same offense. Already over. How can a second trial can be conducted against him on the same offense, on the same facts? So that if it is done, it amounts to double jeopardy. Jeopardy means what? Jeopardy means causing harm or loss to one person. Prejudice. So 2 times cannot be give punishment to one offense to a one person. He has committed one wrong. For that, he should suffer one punishment. But one wrong, there should not be 2 punishments. So, this is Article 20, Class 2 says, and Section 300 says. Of course, there are some principles and everything in detail we will discuss. Only for the purpose of concept of fair trial, outlines we are discussing in this chapter. After that, in detail, we can go. So this is about the concept of fair trial. If anyone has doubts, you please ask. Otherwise, we will close.
Sir, can you please mention the case name which you have mentioned in the expeditious trial?
Husainari cartoon versus state of Bihar.
Okay.
And another point, last point is that decision should be reasoned. It is also very important. If suppose judgment is there, either conviction or acquittal, but no reasons are prescribed, then what about it? Without any reason, if any decision has been there, it is arbitrary. It amounts to arbitrary. It cannot be held for a 1 minute. It should be set aside very next minute if there is any such a decisions are there. So, a reasoned decision. That means decision should have reason. It is also an important point. You note that. So, all these are the principal features of fair trial. Okay. Can we close or any other? Okay.